A recent case argued before the Supreme Court revolved around what's called the community caretaker exception to the Fourth Amendment. Now, this is an excellent example of how constitutional law, which is nothing more than the opinion of judges, is being used to circumvent the Constitution of the United States. So we'll discuss that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. That's right. This is where we read and study the Constitution. We teach the rising generation to be free. I'm glad you could join me. If you want to hear more, I am on America Out Loud and iHeartRadio 5 days a week, 4 p.m. Eastern. Just check out AmericaOutloud.com. Go under shows, look for the Constitution Study. You can listen to me live, and you can follow up with podcasts. That's right. If you missed the live broadcast, you can still listen on podcast. So that's a great way to find out more. You can also find out what's going on at constitutionstudy.com. In preparing for my radio program, I came across this article about a recent case argued before the Supreme Court, and that's what I want to talk about here today, and this idea of a community caretaker exception. Oral arguments were given before the Supreme Court in the case Caniglia versus Strom. Now, the petitioner, Mr. Edward A. Caniglia, has sued Robert F. Strom and several other officials of the city of Cranston, Rhode Island, after police officers entered his home without a warrant and confiscated Mr. Strom's property, specifically 2 handguns, then refused to return them. Specifically, Mr. Strom claimed that the city of Cranston had violated his rights protected by the Second and Fourth Amendments, and that the city violated the 14th Amendment's due process and equal protection clauses. Now, reading from the complaint, quote, "At issue here is petitioner's claim that the entry into his home and resulting seizures, effected without a warrant or civil order, violated his Fourth Amendment rights. The officer's only justification for the entry and seizure was the, quote, community caretaking, quote, exception." Now, the argument made by Mr. Caniglia's attorney was quite simple. Quote, "The Fourth Amendment recognizes the sanctity of the home by drawing a firm line at the door. The government cannot cross that line without a warrant unless there is consent or exigent circumstances. Here, there was neither. Respondent's warrantless seizure of petitioners from his home and their subsequent seizure of his lawfully possessed guns from his bedroom and garage violated the Fourth Amendment." As one would expect, the attorney arguing for the city of Cranston argued differently. Quote, "The question presented is whether the caretaking by police officers and first responders may under certain circumstances take place in the home without a warrant. It should. The petitioner has an absolute petition. Under no circumstances should a warrantless caretaking occur inside a home except upon consent or exigent circumstances. This absolute all-or-nothing approach is contrary to the reasonable standard of the Fourth Amendment, the very touchstone of the Fourth Amendment. There may be circumstances that allow for caretaking in the home absent a warrant, when the advent of the potential harm is not so clear, but the need to respond could be immediate. Time could be of the essence." So the question is, which argument is correct? Now, if I understand the arguments made correctly, the community caretaking exception was something the courts came up with based on hypothetical arguments made in cases like Katie versus Dombrowski, which involved a search of a vehicle in police custody. Now, there is just one problem with these arguments. There is no exception to the Constitution. Period. In order for a search to be legal, it must be reasonable. Now, while the definition of reasonable is not as specific as we would like, that is the standard. Webster's 1828 dictionary defines reasonable as, quote, "having the faculty of reason, endued with reason, as a reasonable being." It also defines reason as, quote, "a faculty of the mind by which it distinguishes truth from falsehood and good from evil, and which enables the possessor to deduce inferences from facts or from propositions." When the term reasonable is used in the Constitution, it is most often referred to as what a reasonable person would find reasonable. I know, circular logic, but that tends to be the standard most often used. The idea of the community caretaker exception seems to be distinguishing between the investigative function of law enforcement and it's merely caretaker functions. However, this brings to light another fallacy about the Constitution. The limitations the Constitution places is upon government, not simply law enforcement. It is just as illegal for a public school official, a census taker, or a city dog catcher to unreasonably search or seize you or your property as it is for law enforcement to do so. For any government official to search you or your property, it must be reasonable. That generally means there must be an imminent threat to someone or that the official has gone to court to get a legitimate warrant. Should a government official with legitimate concerns for the welfare of someone enter a home, they should not be allowed to search it. That would be unreasonable. We've all seen the crime drama where the law enforcement officer, knowing that there's evidence in someone's home, pretends to hear a call for help, then uses that as justification for entering and searching. I know of no reasonable person that would consider that a reasonable search. In the same vein, should law enforcement be dispatched to someone's home for a wellness check? They are there to check on a person's health and should not be allowed to use that as an excuse to search or seize items, even if they're in plain view. Before we go on, let us look at the question of reasonableness in this case. See, after a heated argument between Mr. Coniglia and his wife, Mrs. Coniglia spent the night at a motel. The next day, concerned about her husband, Mrs. Coniglia contacted Cranston police and asked them to escort her home and do a wellness check on her husband. From the petition to the Supreme Court, quote, multiple officers arrived to meet her. Mrs. Coniglia told them what had happened and that she was concerned about her husband's safety, including the possibility that he could be suicidal. After calling petitioner, who, quote, sounded fine, close quote, the officers escorted Mrs. Coniglia back to the home, where they instructed her to stay in the car while they spoke to the petitioner on the back deck. Petitioner told the officers about what had happened and that he had said, quote, just shoot me, quote, close quote, because he couldn't take it anymore. He was calm for the most part, seemed normal, and said that he would never commit suicide. Mrs. Coniglia then entered the home. Say what you will about the wisdom of Mr. Coniglia's words, uttered in the heat of the moment. When interviewed outside his home, the officers found him calm and normal, but they were not convinced. Quote, based on the conversation with petitioner and Mrs. Coniglia, the officers believed there was a risk that petitioner would harm himself. As a result, they summoned a rescue lieutenant from the Cranston Fire Department to the Coniglia's home. That officer told petitioner that he was taking him to a local hospital. Petitioner went along after the police told him they would not take his 2 handguns if he did so. At the hospital, a nurse and a social worker examined petitioner. He was discharged the very same day, but had to pay about $1,000 for the visit. The police officers convinced Mr. Coniglia to go to the hospital for an examination, a trip which cost him about $1,000. Mr. Coniglia would only go after the police told him they would not take his firearms, but that was not the case. Quote, meanwhile, the officers entered the Coniglia's home to seize the petitioner's guns. The officers believed, quote, it was reasonable to do so based on petitioner's state of mind, close quote, and feared that, quote, petitioner and others could be in danger, close quote, if guns remained in the home. After officers falsely represented to Mrs. Coniglia that petitioner had consented, she led the officers to the guns. The officers then seized them. And law enforcement wonders why people don't trust them. First, they lied to Mr. Coniglia about them confiscating his property. Then they lied to his wife about Mr. Coniglia's consent. Now, if the officers thought they had probable cause to seize the weapons, why did they not get a warrant? Police noted that Mr. Coniglia seemed normal, for the most part calm, yet they thought it was reasonable to not only confiscate this man's property, but to do so without any probable cause. If the police officers thought it was reasonable, why did they wait until after Mr. Coniglia had left the premises? And why did they lie to him about their intentions? Yes, the wife stated that she was concerned, but if she thought it was reasonable for officers to confiscate her husband's firearms, why did they have to lie to her about his consent? Then, to add insult to injury, the saga wasn't over. Quote, a few days later, Mrs. Coniglia went to the police station to retrieve the guns. Officers refused her request. A month later, petitioner went to the police station with the same request. Again, the officers refused. When petitioner's attorney made the same request, he fared no better. So we have an illegal seizure of private property, a deprivation of rights under color of law, and law enforcement was allowed to lie during the commission of a crime while acting under their oath of office. Yet it does not seem they have been charged. Instead, we have innocent citizens having to fight for the return of their illegally seized property, property that was not returned until after Mr. Coniglia sued the city. We should not be surprised when those in government attempt to find exceptions to the Constitution, especially when it restricts their actions. And I'm not surprised when government actors in the form of judges either invent these exceptions or use those created by their predecessors. There is no exception to the Fourth Amendment's protection, or for that matter, any other constitutional rules. A search or seizure is either reasonable or not. If government actors could not or do not get a warrant, they need a really good reason to search and seize. It is not reasonable to use the excuse of checking on someone's well-being to circumvent the supreme law of the land. It is also unreasonable and should be illegal for government actors to lie to those they are supposed to serve. If we allow members of courts to continue to violate their oath to support the Constitution, then we are just as much to blame as they are. So tell me, why should those on the district court who found it reasonable for law enforcement to seize property without probable cause and to lie to make it happen, is it reasonable that they should not be investigated for judicial misconduct? If the people of this country cannot trust their courts to abide by the law they swore or affirmed to uphold, then we must demand our representatives in the House do their jobs and oversee the court. And if we cannot trust those we hire to represent us to do their jobs, then it's about time we found better people to represent us. I always love when judges and lawyers find exceptions to the Constitution, as if they can write in rules that just aren't there. The Fourth Amendment doesn't say you'll be safe from unreasonable search and seizures, well, unless someone's checking on your health. There is no community caretaker exception. If you work for the government, it is illegal for you to search or seize without probable cause. You cannot enter a person's property without probable cause, and you cannot search or seize their property without probable cause. That's what makes it reasonable. And the only time you're allowed to do so without a warrant is if there's what's called an exigent circumstance, meaning it has to happen now. Since Mr. Coniglia had gone to the hospital, was it really that hard for the officers to pick up their cell phones and call for a warrant? If they had probable cause, they could simply swear, yes, he looks to be a danger, his wife is concerned, we think there's a problem, can you give us a warrant? And then when they decided not to charge him, the answer was real simple. You give him his stuff back. This isn't an exception to the Fourth Amendment. This is theft under color of law. And it's we, the people, who let it happen. The people of Cranston and the people of Rhode Island should ask themselves, what kind of banana republic is this? Where law enforcement can lie and make up excuses in order to get into someone's home and confiscate their property on the thinnest of possible causes. And the people of America, what does it say that we have judges who are part of our government, who work by our consent and in our name, will ignore such a blatant violation of the supreme law of the land? Now, I don't know how the Supreme Court's going to opine on this. I'm kind of curious. But I do know that those in the district court failed. They committed judicial malpractice. They should be investigated. And if they're found guilty, they should be punished. Such an abuse of the Constitution should not be allowed to stand. Even the idea that the Constitution has exceptions that are not written in its text is a violation of the consent of the governed. The reasonable search and seizure is not something pulled out of thin air. That is the consent of the American people to the limitations on government. And no, Mr. Biden, the Second Amendment doesn't have its limitations either. The right to keep and bear arms shall not be infringed, period. Whether it's police illegally entering your home and confiscating your property, or the President of the United States trying to get other people to confiscate your property, it's illegal. And the American people shouldn't stand for it anymore. If we will not hire people to exercise our power that will follow the rules, we can't complain when we live in a banana republic. And if you won't stand up for Mr. Caniglia's rights, don't expect anyone to stand up for yours when they come for your guns, when they come for your medications, who knows, when they come to force you to get a vaccine. These are not simple little unimportant things. These are the heart. They're the foundation of our liberty. That government is established by men and only exercise just power by our consent. That being the Constitution of the United States and the Constitution of the several states. And if they will not follow the rules and we will not hold them accountable, the fault for our mess is ours. And it's only by recognizing that, by realizing our mistake, that we have a chance to fix it. If we want to remain the land of the free, we'll have to once again be the home of the brave and stand up to tyrants in government who think they can run roughshod over the Constitution if they feel like it. So find out more over at constitutionstudy.com. Hey, join us on Constitution Scholars. We've got a great group going where we're meeting and discussing and asking questions and talking about this and other constitutional issues. You can find out more at constitutionscholars.com, and you can find out what I'm talking about next week right here on the Constitution Study.
There's one thing you have to